In the last lecture delivered by me, I had discussed about the pleaders to be engaged by the party for filing the suit. Now I am sorry that I could not upload the videos at regular intervals. Now from onwards I will try to upload the videos for your information, knowledge and better understanding of CPC. We come to Order 6 of the CPC. Order 6 deals with the heading pleadings generally. Why the word generally has been given or used by the legislature? It means that these pleadings, these rules contained in Order 6 are not applicable only to the plaints but also to the written statement to be filed by the defendant. So these are the general principles of pleadings. Now the only thing which will come to the mind is that what is the pleadings? Pleading means that we are to give our version of our case in writing before the court. When we write our grievance before the court, only then the court will be calling upon the other party to give a specific answer to the queries or the points raised by us. Now this is a lengthy order. We will have to discuss the same in two parts. Now pleadings according to Rule 1 means plaint and written statement. Plaint means which is filed by the plaintiff, and the written statement means which is filed by the defendant. Plaint is filed by the plaintiff under Order 7, while the written statement is being filed by the defendant under Order 8. Now, the only question which will immediately crop up in the mind is that generally replication is also filed, and the courts do ask for the filing of the replication. There is a judgments of the Honorable High Court and the Supreme Court which say that pleadings is a part of the replication is a part of the pleadings, while some say that replication is not a part of the pleadings. The question arises that what is the correct answer to this? According to me, when a new fact is stated by the defendant in the written statement, or certain legal objections are taken by the defendant in the written statement, and then those objections are to be given a befitting reply. In the absence of a befitting reply being given by the other party to the fresh allegations contained in the plaint or in the written statement, the same will tantamount to an admission on the part of the opposite party that it had nothing to say regarding those objections or the new facts stated in the plaint or the written statement. I will be discussing under Order 8 Rule 6 CPC that written statement can be amended by the parties or the defendant when a new fact has been alleged by the plaintiff, or the plaintiff can file an additional reply to the written statement. So now one thing is apparently clear, that pleadings means plaint, written statement and replication. If the Honorable Court does not grant you the permission to file the replication, then you can move an application before the court to the effect with a prayer that you may be allowed to file the replication to controvert the allegations or the substance taken by the plaintiff or the defendant in the written statement or in the plaint. So replication by and large is a part of the pleadings. Now we come to Order 6 Rule 2 CPC. Now pleadings, what does it mean? It says that only the facts are to be pleaded in the plaint. No evidence is required to be pleaded in the plaint by which the said fact is to be proved by the party. It says that every pleadings shall contain and contain only. Now the emphasis is on the word shall contain and contain only. The legislature was not at a loss to use the same words again and again in the same rule. The intention of the legislature was that facts are to be stated. Now I say, let us take an example. I say that defendant has borrowed a sum of ₹1 lakh from me and he has executed a per note, that is promissory note in my favor, acknowledging the receipt of the amount and undertaking to pay back the amount of ₹1 lakh along with interest to me. Now borrowing of the loan, execution of the per note and the receipt is a fact which has to be pleaded by me. It is not necessary that I have to say that he had borrowed the amount in the presence of such and such witness and such witness had signed the per note and what the said witness is going to depose regarding the execution of the per note and the receipt. So meaning thereby that it is only the facts which are to be stated and not the evidence by which it is required to be proved by the party concerned. Why it is so? Because in case the evidence is allowed to be pleaded in the plaint or in the written statement, then the pleadings will become so lengthy that it will be very hard for the court or difficult for the court to decipher the same. Secondly, the opportunity to produce evidence shall be granted by the court after it has found that the parties at issue. There is an assertion made by one party and denied by other party, which is culminated in the form of an issue which we will be discussing while we will discuss Order 14 of the Code of Civil Procedure. So meaning that ultimately we come to this conclusion that it is only the facts which are to be pleaded and not the evidence by which the same are required to be proved by the party. In case, now the second requirement is that what are the facts which are required to be pleaded. The legislature in its wisdom has said that it is the material facts which are required to be put in the form of the pleadings. Material means which facts are required, which are essential for the decision of the controversy between the parties. It is not that each and every fact is a material fact. When we had taken the case example or of a execution of a promissory note, now the plaintiff can say that such and such amount was borrowed by the defendant from me on such and such date and he had agreed to pay the interest. Now execution of the per note is a material fact which is required to be pleaded in the plaint so that the other party has a chance to give a reply thereto. It is not sufficient to say only that a sum of rupees so and so was borrowed without giving the date, month and year of borrowing and what were the terms and conditions on which the amount was borrowed. So material facts are required to be pleaded in the plaint or in the written statement by the parties. Then the evidence is to be led on the basis of these said pleadings. Where we can compare the pleadings to the foundations laid down by a party. Foundation means, suppose you are constructing a building, you are constructing a mall which is having 32 stories. Now if the foundation is not strong enough to bear the load of 32 stories, then it has the chance, or there is every likelihood that the building can fall at any time. So the pleadings are the foundations of each and every case. In the absence of the pleadings, nothing is complete. I am reminded of an Urdu couplet which clearly clarifies the emphasis or the importance attached to the pleadings. वो बात जिसका सारे फसाने में जिक्र ना था, वो बात जिसका सारे फसाने में जिक्र ना था, वो बात उनको बहुत नागवार गुजरी है. Meaning thereby that if I have not said anything in my story, then that will not allow the court to give a finding and a decision on the point. So emphasis is always on the material facts to be pleaded in the plaint. Then the pleadings are to be divided into sub-paras. It is not that an essay has to be written. Small paras containing each and separate fact has to be pleaded in the pleadings. The importance of paragraphs is that it is ready to read and ready to imbibe. The meaning of small paras will clinch the case which is being put forth by the plaintiff or the defendant. If there is a lengthy para and in the form of an essay, then one may lose the interest in reading the plaint or the written statement. So it has to be divided into sub-paras which are to be numbered consecutively. Then comes form of pleadings. Now legislature in its wisdom had annexed Appendix A with the Code of Civil Procedure. Part 1 of the Appendix A says that how the title of the suit has to be there. Part 2 says that how the parties are to be described. Details have been given. Then Part 3 deals with the journal performance of various types of plaints which can be filed by a party by a plaintiff or a part against the other party. So legislature has not left to any chance anything so that the procedure may not become cumbersome. Party may be at ease to understand and plead the case by taking help of the formats given in the plaint. It is not necessary that the format has to be copied. The wording of the format given in Appendix A, Part 3 has to be in accordance with the facts of the case and can be substituted or altered by the additional facts. So form of pleadings has been given by the legislature in its wisdom. Then comes Rule 4. Now if the plaintiff is pleading and relies on any misrepresentation, fraud, breach of trust, willful default or undue influence in his case, then he has to give the details of all these particulars. Now all these particulars, misrepresentation, fraud, breach of trust, willful default, undue influence, are contained in the Indian Contract Act. A contract can be avoided by the other party if he is able to prove any of these ingredients or criteria to say that the contract is vitiated. So when the plaintiff is trying to impugn a particular contract, then he is required to give the details of such misrepresentation, breach, fraud, breach of trust, willful default, or undue influence, and the terms has to be given with the particulars, dates and items, if necessary, shall be stated in the pleadings. It is not that I can say while filing the suit that a fraud has been played by the defendant upon me, or the defendant had obtained the contract under undue influence. I have to give the details thereof, how the fraud was committed, where the fraud was committed, in what manner the fraud was committed, what loss has acquired to me by the commission of the fraud. Similarly, how the undue influence was had taken place, or how the undue influence was taken by the defendant with me while obtaining the contract. There has to be a person in dominating position, and then the second party must be in a subservient position. So all these facts are to be pleaded with the details and particulars and items thereof. In the absence of the particulars, the general allegations of fraud, undue influence, breach of trust, etc., are not sufficient. They are to be given in detail. In the absence of any details, no evidence can be led. Now the question will arise that these are the questions of fact which have to be led by the party. No doubt it is a question of fact, but the details as to how the fraud was practiced, how there was a willful breach of trust, or there was undue influence, the material facts regarding the same have to be given in the pleadings. In the absence of that, the pleadings is deficient. Then condition precedent. Now there are two types of conditions. One is condition precedent and second is condition subsequent. Condition precedent means the condition, performance or occurrence of which is intended to be contested shall be distinctly specified in his pleadings by the plaintiff or the defendant, subject thereto, or averment in the performance or occurrence of the conditions precedent necessary for the plaintiff or the defendant. Suppose I file a suit for specific performance. There has been an agreement of sale between me and the defendant. Defendant refuses to get the sale deed executed. Now it was incumbent upon the defendant to obtain the permission from a particular authority before executing the sale deed in my favor. So this is a condition precedent which has to be fulfilled by the defendant before he is competent to execute the sale deed in my favor. So this is a condition precedent which I have to specify. Suppose the defendant has to get the property demarcated or to get the property partitioned from the other co-sharers. So in those circumstances, the condition of getting the permission or getting the demarcation or getting the property partition is a condition precedent on the basis of which the entire scenario of the suit is based. Then, in case such a condition precedent is not fulfilled by the plaintiff or the defendant, the result may go against him. Then comes departure. It says that no pleadings shall, except by way of amendment, raise any new ground of claim or contain any allegation of fact inconsistent with the provision with the previous pleadings of the parties pleading the case. Now, meaning thereby that whatever has been said by you, that is the last word. You cannot amend the plaint unless and until, or you cannot amend the written statement unless and until the same is permissible under law, which we will be discussing while discussing Order 6, Rule 17, which says that amendment to the pleadings can be made by the party. So meaning thereby that no departure can be made from the pleadings made by the parties. Then denial of contract. If there is a contract which is being denied by the defendant or by the plaintiff, then a mere denial is not sufficient. It is not sufficient for either party to say that he denies the contract. He is to give the facts and circumstances under which he is denying the legality or sufficiency of law of such contract. So meaning thereby that mere denial is not denial, it has to be legal. Why he is denying the execution of the contract, particulars are to be given. Then effect of the document to be stated. Whenever the contents of a document are material, it shall be sufficient in the pleadings to state the effect thereof as briefly as possible, without stating out whole or any part thereof, unless the precise words of the documents or any part thereof are relevant. So meaning this rule says that effect of the document is to be given. I had taken you the example of execution of a promissory note. I had said that defendant had borrowed the amount. So I say that what is the effect of that document? That despite the execution of the document, despite the fact of borrowing of the amount from me, he has failed to pay the interest or the principal amount to me, despite the fact of execution of the note. So the effect of the document is to be stated that I called upon him to make the payment of the principal and to make the payment of interest, but he point blankly refused to do so, or he denies his liability to pay the amount of principal or the interest thereof. So these are the facts which are to be stated. It is not that the contents of the document are to be repeated. I can exhibit the document when I will be leading the evidence. In leading the evidence, when the document is exhibited, then the contents of the entire document are admissible and can be read as evidence. They are part of the judicial file. So therefore, the effect of the document has to be stated. Now, with this point in mind, I will give a rest to the lecture here. As far as the rest of the order is concerned, from Rule 10 onwards to Rule 18, we will be discussing in detail in the next lecture. First of all, you are requested to subscribe to the views taken by me, and if there are any queries which you require or which are not clear to you while hearing this lecture, you are free to contact me by email or through my telephone number, and I will be happy to give the answer to all the queries being raised by you. Thank you.